because we don't know. We're hoping one of our other folks will come out of the courtroom and give us some idea of what happens next and what the magistrate had to say. But what are you going to be looking for? What are the key moments that people should know are coming now that these charges have been formally made and the president has been booked and is in that courtroom right now?
Yeah, so I think the headline coming out of today, as we knew, is Donald Trump is now officially under arrest. He has now been indicted twice, he's been arrested twice, and he's been impeached twice. And of course, in this proceeding in Florida, he'll be entitled to the presumption of innocence. But if his defense is what we just heard from Mr. Parlatore, I don't think that he's got much of a defense. So I expect the first set of proceedings to be some sort of challenge to the indictment, a motion to quash the indictment, to throw it out because of this alleged prosecutorial misconduct. And it was notable to me that the only thing Mr. Parlatore could come up with was an abuse of the attorney-client privilege. And if you just pointed out, that was his 45 examples. I mean, give me a break. That was litigated to the chief judge in D.C., Beryl Howell, an extremely respected judge who threw it out. And then it went up to the nation's second highest court, the D.C. Circuit, which also threw it out. So if that's the best he's got, he doesn't have very much. Now, I do think
I'm sorry. You keep going.
I do think that there will be a motion to also try and suppress all this attorney-client stuff. So I think, even if it's not misconduct, they're going to try and say it's wrong for the evidence to be admitted in Donald Trump's criminal trial. If Judge Cannon is presiding over that, I think that's all the more reason why, if she's going to be making these big, important decisions, the American public need to see that in a televised, live way, as opposed to reporters telling us what happened after the fact by giving us their own recollections and the like. But in any event, I think that the timeline here is quite a long timeline. This is not something that's going to move quickly. Jack Smith has said he could present this in a matter of 3 weeks in a trial, but I think, we're talking many months before that trial. There's also going to be classified information questions under the Classified Information Procedures Act, but I see no reason why this trial shouldn't take place in the fall of this year. I think it'd be a mistake to delay it any longer. Trump is obviously going to try. That's his modus operandi. It's always delay, 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 and he hopes that a Republican will win in the November 24 election and to terminate this prosecution.
And Neil, I know that you are someone who has won more appeals before the United States Supreme Court, more cases, I should say, than almost anyone I know. So you've got an extraordinary record. I'm sorry, what were you saying?
So you know two people. So go ahead.
Well, so that's an extraordinary record. Let me ask you, because I didn't quite understand Mr. Parlatare's point. Is he saying that it was pierced in a limited way for the grand jury testimony to have Evan Corcoran be able to testify, but that testimony should not be allowed in evidence at the trial?
That's exactly what the move is they're going to make. They're going to first call it prosecutorial abuse. I think that will go nowhere because, this was stuff that many judges in Washington, D.C. signed up for. But they'll then say, okay, if it's not prosecutorial abuse before the grand jury, at least when Donald Trump is tried criminally, you can't use his own attorney's words against him. And if that attorney were giving pure legal advice, that would be a good argument. But what Judge Howell did here in this case is say, yeah, there is some stuff from Corcoran that is truly legal advice. Like, here's what the law is, Mr. Trump. But there's other stuff in which Trump is trying to get his attorney, Evan Corcoran, to commit the crime. And it's in paragraph, if the American public reads anything, they should read paragraph 54 of the indictment, which was released last week, because that's what it's all about. It's all about basically saying things like, do we really have to turn this information over? And, it'd be better if it wasn't turned over, and things like that. So that's why the judge made the really rare decision of pierce attorney-client privilege and why it was upheld by the D.C. Circuit.